Okay, we are going live.
Good afternoon, everybody. My name is Feroze Boda. I've been asked to coordinate this talk, which has been hosted jointly by two organizations, Access HR Consulting and Aequitas. And the topic we're going to discuss today is a fresh and radical approach to the draft code on the prevention of violence and harassment in the workplace. We have three excellent speakers. The first speaker is going to be Dr. Annelie Gildenhuys. She was party to drafting the draft code, and Annelie is a sociologist. She'll give you a perspective from that dimension. And then we'll have two lawyers speaking, one local lawyer, George van der Merwe, and one foreign lawyer, Makbool Javaid from the UK, and they'll be giving a perspective from an international perspective. This is clearly a topic where people should be ahead of the game and should plan and make sure that their policies are compliant in advance of the draft code actually becoming law. So without further ado, I'm going to call upon Annelie, and she's going to talk to you about the drafting and status of the proposed code. Annelie?
Thank you very much, Feroze. Thank you, everybody, for joining us. I think what I would like to state up front is I'm not going to go into the code itself because, but you're welcome to have the content thereof. The background to this is that we all operate in a context, and this context is changing, and it's no secret that internationally and in South Africa, there has been a revolution against any form of discrimination. South Africa is a member state of the International Labour Organization and has been very much involved in the prohibiting discrimination. But in July 2019, the ILO at its conference adopted a new convention and recommendations. South Africa was very much involved. And this convention talks about the elimination and prevention of violence and harassment in the world of work. And it's interesting here that the focus is on elimination and prevention. The other interesting aspect is that violence and harassment has become one word. It's one noun and one concept in this convention. And then it addresses the world of work and not the workplace. So it includes a very broad interpretation of violence and harassment and various forms thereof. And the ILO has called for an integrated approach to prevention and protection, rehabilitation, compensation, and remedial action. And South Africa, through its Commission of Employment Equity, Department of Labour, supported by NEDLAC, has said that it wishes to ratify this convention and accordingly published then a draft code, and it was really an all-in-one code. The attempt was to align as closely with the ILO convention as is possible. The code was published on the 20th of August, and it was submitted to NEDLAC, very much in support of it as it is, and it was then tabled for discussion. The comments closed on the 21st of October. There was quite a plethora of comments on this. And currently there is a NEDLAC task team dealing with this and considering the comments for public drafting. So it is possible that the code in the end lands very differently, but what I am very sure of is that the contents thereof in all of the forms are supported, and there's quite a political drive to accept this code. Now, it stands just to reflect a little bit in that South Africa's labour law framework, we've got law. In our labour law in the Constitution, the Employment Equity Act, and particularly the Code on Handling Sexual Harassment in the Workplace, the 2005 Code, remember the 1998 was repealed. And the Code of Good Practice on the integration of employment equity into HR policies and practices are referred. It is envisaged that these two codes would be repealed in accepting an overall integrated code. Now, the Labour Relations Act already deals with violence as a form of misconduct, and the Occupational Health and Safety Act deals with occupational health and safety, and it is long accepted, or it's tried to accept that this does not only refer to physical health and safety. So harassment was really much undefined in South Africa, and then there were specific interventions. And the reason I'm raising this is that we have got several pieces of law all addressing what the convention wants. The challenge that we have is that these two codes that we're working with have two different definitions. We have different definitions in PEPUDA and PFHA. So what the code tried to do was to get one document, one concept, one test, and one definition in order to have clarity. The problem is not that we don't have law. The problem lies with the implementation thereof. And very specifically, Section 60 of the Employment Equity Act was not amended. The Act has not been amended. And of course, the prohibition and damages is dealt with in PEPUDA. Now, interesting is already that much of what is in the code, I would argue, is already in the Employment Equity Act, in the obligations under the implementation code of good practice and the affirmative action measures that has to be taken and measured to prevent and eliminate all forms of discrimination. And harassment is, of course, discrimination. Now, I'm going to not go through Section 60 as much as I said that it has dealt with it. It talks about the liabilities of the employer, which George will talk about a lot more, and it deals with the obligations when an incident happens while at work, and it must be immediately brought to the attention. We must take the necessary steps to eliminate, and if you fail, the employer is then directly and vicariously liable. Now, the employer needs to prove that it did everything that is reasonably practicable, not practical. Now, this has remained unchanged. The new code proposed introduces definitions. It talks about a much broader scope of application. The scope is very much the same as the 2005 code with two additions. And it talks about the objectives and the guiding principles. But what is interesting here is the main forms of violence and harassment, and that it introduces, as I said, a definition, the elements, how it manifests, and the tests. That's the first part of the code. The second part of the code actually just puts in one document that is already there, is how do we prevent, eliminate, and manage. So in other words, your proactive and reactive actions. It talks about realistic awareness. And when an event does happen, it talks about treatment, care, and support. It addresses the issue of privacy versus confidentiality, and then it speaks to the procedures to manage all forms of violence and harassment, and then it talks about how to monitor and evaluate. Now, the monitoring and evaluation is already part of the Employment Equity Act and is no different. So I think that, as I've said, that the scope is very much the same as the 2005. It has also included job seekers. The difficulty at the moment is that we adopted the violence and harassment as one definition, whereas South Africa's case law has very much dealt with violence and harassment as two separate concepts. I'm going to then just state that the categories of violence in here, what it reaches or perhaps overreaches in this code, is that it talks about self-directed violence and dealing with it, interpersonal violence and harassment, and then collective violence and harassment, group on group or group on individual or individual on individual. The main forms included is sexual violence and harassment, and throughout the code it says and gender-based violence and gender-based violence. Of course, sexual violence and harassment is a form of gender-based violence in the broadest concept of sexual orientation, sexual identity, and sexual expression. What is interesting, and I'll stop with this, is that domestic violence has also been brought into the world of work, in as far as the impact of domestic violence has an impact on the health and safety of your colleagues and of the individual. And this is quite new, whereas formerly I think we all said that that was something private. Domestic violence has been brought into the realm. Then racial, ethnic, or social origin violence and harassment, and then workplace bullying and mobbing, and protected disclosure. Protected disclosure is much dealt with. The challenge we have with workplace bullying, of course, is that the latest court case law in our country says that bullying is a form of harassment, but since it's not on a listed ground, doesn't fall in discrimination. So there is a difficulty in where workplace bullying will lie, but the fact that workplace bullying is acknowledged and that all the social partners believe that it forms under violence and harassment is definitely accepted. So as I said, this code, all in one, tries to define the main forms, not limited to, raise the factors, and then be clear on the test, because we do know that many CCMA commissioners and judges have applied different tests, and we've had very inconsistent outcomes in all forms of violence and harassment. And so the code attempted to describe it, give examples, give definitions, and also the test to be applied in all of it. And the definitions that I refer to is specifically that of what is bullying, and that bullying and violence and harassment in the world of work, place and space is online and cyber, which stands to reason, and that it includes physical violence and psychological violence. And it adopts the term worker versus employee, and as I said, world of work versus workplace. Now, as I mentioned, South Africa already, the HIV, AIDS and TB code already talks about world of work, so it's not new, and then defines it. I think what one did realize here is the attempt to use definitions from the various, from the PFHA, the PAPUDA, from the two codes, and then the government framework on GBV and femicide, is to try and get a coherent one set of definitions in all of that. And the rest of the document deals then with the tests, which in all of it aims to not be a purely subjective or a purely objective test, but to be a balance in the reasonable behavior, the reasonable complainant and test. So much of the tests have remained with what is existing there, except there are two areas that has been added, I think, going back to the 1989 code, or 1998 code, and that is that in the case of sexual violence and harassment, is that it doesn't only need to be persistent, it could be a once-off behavior where the recipient has made it clear that the behavior is offensive and the perpetrator knows or ought to have known. Now, it's interesting that there is quite some comments around this in that a recipient could make it known in various ways that the behavior is unwelcome or offensive. The code then attempts to do a racial, ethnic or social origin violence and harassment definition in particular, and then gives the test as well as unwanted, persistent or serious, which demeans, impaired the dignity, humiliated or created a hostile working environment, or was calculated to induce, related to race, ethnic or social origins. And again there, whether a perpetrator would have spoken these words or behaved in that manner. So it's the but-for test. And then it deals with workplace bullying, and I'll end there. I think that many people are concerned that bullying would merely be where I don't like my manager or I object to an evaluation. And the test for workplace bullying adopts a very stringent intolerability test of what the hostile environment is, and that it is not to be endured. Whether bullying would remain in terms of the Employment Equity Act in this code, or whether it belongs under health and safety in the LRA, is then what would needs to be considered in the final drafting. The rest of this document talks very much about what are the duties of an employer to prevent, to eliminate, to manage when it happens, all forms of violence and harassment. And as I said, it speaks back to Section 60, it speaks to the existing codes we have, but what remains here is that the employer has a very proactive duty to prevent harassment and violence, and then to support and deal with matters immediately. And the rest of the code then talks explicitly on what is meant with awareness. And it doesn't use the word should, it uses the word must train, must create awareness, must do these interventions. And I think that is particularly then in the remainder of the code what you would find in existing codes and in existing application of law as it stands. And with that, I'm not going to go through the rest of the code because you're welcome to read it. It was published with quite a number of omissions and paragraphs and grammatical errors at the printers. But we do foresee that whilst the code is very likely to change, the concepts that are in here and whether violence and harassment is adopted as one term or two separate terms, the issue of sexual harassment, gender-based violence, domestic violence, racial and ethnic and social origins, and bullying is likely to be on the agenda as it is supported by the social partners at NETLAC. And with that, I'm going to, in the time that I have, then finish with this Feroze, and I'm not sure if we will deal with questions later.
Thank you very much, Annelie. We still got a few minutes before George can take on his presentation. And we do have a question, and it's something that also popped up in my mind. How would the regulation of domestic violence work? Given that the EEA applies to employers and employees, if you can just sort of explain how that would become relevant. Is it in the circumstances where there's employment relationships in the household, or would it transcend into the workplace, and if so, how?
Well, the definition of domestic violence was adopted from the government's document, but yes, it is foreseen as where it starts affecting the workplace. Now, the individual victim is used here as opposed to complainant when it affects work and self-directed violence, and where it places the health and safety of others into danger, like stalking, or when the violence spills over into the workplace. And it talks about how you can reasonably accommodate such a person, such as under incapacity, ill health, with additional leave, helping with compliance and restraining orders, and ensuring that other employees are not affected by the violence. But it is acknowledging that your workers' problems does not stay at the gate, but does impact. So it is as far as it impacts the world of work as it is foreseen in the code.
Thank you. And then we still got a few minutes, so I'll ask you one more question about this concept called the world of work. You know, how would that, it seems to be a wide term. And the question is, would an Uber driver who is not an employee be in a position to rely on the EEA that only applies to employers and employees?
Yeah, well, the existing 2005 Code on Sexual Harassment already foresees that everybody who has got dealings with the business, if my employee is being subjected to violence and harassment by my client or my supplier, what happens then? How do I, as the employer, support proactively and reactively? And of course, we have got the PFHA and PEPUDA legislation. So when my employee is affected by violence and harassment through external perpetrators, and how that support and prevention duty handles, or similarly, when my employee perpetrates violence and harassment to an external party. So that's the one area. And the other area, which has already been made by the code, the 2005 code, and has already been very specifically stated by our labour appeal courts, is that workplace and space has gone mobile. So if I'm in work-related training, or it happens at a pub after work, and there is a nexus between my employment relationship and the incident happening, you can't say anymore that this is in my office. It only happened in the office and it worked between 8 and 5, because we know that cyberbullying, and all of us now really know what it means to work flexible workplace and space. But it is when it is related to my role as an employee. And interesting, as I mentioned, it's not new for South Africa to use the term world of work. And if you look at the application and scope of the draft code, as I mentioned mentioned earlier, as we have it in the code now, it's not much different to what is already in the existing 2005 scope, in that the Employment Equity Act talks to applicants for a job. Here we include job seekers, and then everybody who has dealings with the business is not much different as to what we have already, and in that concept of world of work. I think I might just add that, I mean, we know that it is under the Employment Equity Act, it deals with the employer-employee relationship, but where it comes to our shareholders, stakeholders and parties outside, as I've mentioned, very often our employees are, it talks about those who are more vulnerable, for instance, those that work in the hospitality industry are more subjected, or those who work at night, or public nurses are more subjected to violence and harassment being perpetrated by the clients that they serve. So the code aims to for the employer to acknowledge that employees, they are a group of employees who are particularly vulnerable due to the nature of their employment. And so that concept makes that clear. And I think lastly, what has become very clear to me over the last number of years in cases is also that when employees are subjected, or when employees perpetrate, we're not always sure, when is it PFHA, when is it PAPUDA, when do I go to the police, when is it my employment relations? And I think much of the public comments have asked for being clear as to when that happens. And I know George always talks about the secondary and primary relationship. But so I don't particularly see the world of work as very new for us in South Africa, in that it is already the scope and application meant by that word has already been clarified to a large extent.
Thank you very much, Annelie.
And I think thinking about, yeah.
Thank you. I mean, I think that just for those who are looking at this, this is something that your policies should actually, consider, and employers who draft their policies need to look at their workspace, how far-reaching their world of work is, and make sure that their policies cater for every possible area of risk, and a risk assessment needs to be done in relation to all potential areas within the world of work. So I think George will look at this more carefully. He's our next speaker. Thank you very much, Annelie. It's very helpful. You've given us an overview of what the code actually does, what it regulates and how it regulates it. And George is going to look at some of the legal implications and risks more carefully. So without further ado, I'm going to call upon George van der Merwe to do his presentation. George is a well-known attorney in town, and he has a keen interest, and I would put him as one of the top specialists we have in this country who deals with sexual harassment cases specifically. So thank you very much, George, and over to you. George, you're just on mute. If you just unmute yourself.
Thank you, Feroze. Thanks for that, and thanks for the introduction. Thank you, Annelie. So we most certainly are planning on having some fun in looking at this presentation. Feroze, can I just confirm? I just want to see that I am screen sharing and that the presentation is in fact coming up.
I don't see it on my screen yet, George.
Is it not up yet? Give me 1 second. Just want to see if I do this. Is it up?
No, not on my end. Yes, I see your. Oh, it keeps on flipping back to the. Yes, it's there. Thank you.
Okay, thank you very much. So thank you, everybody. So the main focus of this presentation is what you find right at the bottom of this opening slide, being a simple approach to a complex matter. And here we go. So the idea was to take sexual harassment and racial harassment topics and look at it from a different perspective. So effectively putting it on its head for a moment and taking a step back and getting out of the detail and then looking at it from above, if you want to call it a helicopter view. And this is what these slides will do. Now, this is an overview of what the slides will be taking us through and what I will be talking about. Firstly, why is sexual and racial harassment complicated? So it's first just a conceptual understanding or a discussion point on why is it complicated and why are we experiencing as complicated. The second one, what is the jaw-dropping moment when it comes to sexual harassment, specifically sexual harassment, and I'm using the words jaw-dropping moment intentionally because I intend to underline and emphasize what is the big deal about sexual harassment and why do we have a legal approach to all of this that is effectively, I would say, waking up society, so to speak. The third bullet then gives you a feel for what we will look at then. It's a flyover in respect of employer duties. So we'll then bring it home. We'll bring it home to identify the employer duties and effectively go to the fourth bullet, which is a fresh approach and effectively going back to basics. So stepping out of the detail, asking, well, what is the basic purpose of what we're trying to achieve? And then looking at all of the detail afresh to see how and are we achieving the basic principles that's behind it. So the first slide, simple slide, but there's a lot in it. Why is harassment complicated? And you will see that the heading basically talks about harassment, not just sexual harassment, because I am presenting the point that both sexual harassment as well as racial harassment will lie within the sphere. Now, this is why it is complicated or perceived to be complicated, i.e. not a traditional employment law or a HR topic. It's complicated because you've got a number of role players. Now, what you can see on the slide is you've got the employer sitting at the top. There's certain rights and obligations that flows from and to the employer. You've got the complainant and you've got the harasser. So you've got three different parties just on the slide, and there's rights and obligations flowing in all the directions. Let me just make this point. Normally, when you deal with misconduct, which is not the case when you deal with sexual harassment or racial harassment, normally when you deal with misconduct, there's only two parties in play, and that is the employer and the person who committed the misconduct. With sexual or racial harassment, there's three parties in play. There's not only three parties in play, so just standing for a moment with a complainant. It's in play because the complainant gets rights and obligations. The Sexual Harassment Code, if you think about it, why was it drafted? It was drafted to make it clear when the employer will accumulate vicarious liability or take responsibility in respect of what has happened to the complainant. In other words, the complainant can effectively hold the employer vicariously liable and sue for damages or claim compensation if the employer hasn't acted as prescribed by the code, for example. And if you pause for a moment and you think about Annelie's presentation, her presentation was all about how do we eliminate sexual harassment and, for that matter, racial harassment. Now, those duties on the employer, once you fail in those duties, and I'm now talking about and referring to Section 60 of the Employment Equity Act, once you fail in those duties, the employer is deemed to have committed the discrimination, and that's where the liability comes from. So it is complicated because of the three role players within the sphere, but it's then complicated further if you look at what lies behind this. And that is, what lies behind this, of course, is that you also have a duty towards other employees, not just the three role players in the picture at the moment. So that employer sits with a duty towards other employees in terms of providing a safe working environment, making sure it's free from sexual and racial discrimination, etc. And it's in that environment where things like an anonymous helpline for sexual harassment comes up. Now, I know as I'm saying these words, very little of you will put your hands up by saying we have an anonymous helpline for sexual harassment complaints. You will say we have an anonymous helpline insofar as general whistleblowing complaints or criminal actions are concerned. But what I intend to raise is I intend to raise questions in this presentation to ask this, and that is that truly the assistance that the code is talking about? In other words, when an employee is struggling with whether or not what has happened to me is sexual harassment, is your anonymous helpline indeed the helpline that it is supposed to be? So I'm making the point we need to appreciate how and to what extent sexual harassment, the code, employer duties actually go to. So it's not just that, and also Annelie's point about the world of work and effectively playing outside of the employment space complicates the matter even further. So that's something on why it's complicated. Now, you will recall in the interview I spoke about the jaw-dropping moment. Now, we have international guests on our webinar today. So I did refer to Campbell Scientific Africa versus Simmers. This is a Labour Appeal Court case that was decided in South Africa in 2015. But this is for me the jaw-dropping moment, and I want to land it as a jaw-dropping moment. I'm using simple words so that it serves as a takeout after the presentation. And this is what happened. Our first judge, Judge Steenkamp, looking at these facts, a man saying to a lady after hours at a restaurant, they were there on a holiday trip up in Africa, but effectively the man said, I feel lonely, do you want to come to my room? Perhaps you want a lover tonight, you can come to my room. No, I have a boyfriend. The first judge, the Labour Court, looking at these facts, effectively says this is not sexual harassment. This same matter goes to the Labour Appeal Court, and the Labour Appeal Court overturns that judgment, and the Labour Appeal Court says this is sexual harassment. So I want to land the point this way. The first judge most certainly experiencing a jaw-dropping moment when the Labour Appeal Court calls it sexual harassment. And that for me is where the key lies in us understanding what has happened to the world and where we are now, and we've been there since 2015. Our new code and the ILO convention, in fact, is shining a light on it. But I think a real appreciation of what this does and what this requires of employers are especially important. Now, this slide, quite a busy slide. My intention is not to take you through everything. It is a statistical slide from YouGov, from YouGov.com. And it effectively shows to us a bit of a graph and an understanding of what constitutes sexual harassment and how is it perceived by different genders and generations, and an appreciation that they see things differently. Now you see the key on the right hand side, it says women, that is the brown line, women, and it starts off between the ages of 18 to 24, and then it goes to the age of 56, and men is the green line, also starting in those age groups, but effectively showing to us how genders experience things differently. I'm not going to look at the first 5 of those graphs because they are pretty self-explanatory, but I'm going to start with the one in the middle, a man directing sexual jokes at a woman. And you will see that there's a script there at the top saying the biggest difference between age groups is over wolf whistling, and the one just on the left is the one about sexual jokes. And the point that I want to make here is the following. So what the graph shows you, yes, it shows us how different generations and genders perceives sexual harassment, so it most certainly shows us that, but it shows us something else, and that is the white part at the top, where the graph does not actually go. It tells us, and I'm just dealing with a man directing sexual jokes at a woman, the one in the middle just above the number 1. It shows us that sits at a 70% perceived level. So what it tells us 30% above that, which gives you the rest of the 100, effectively did not see directing sexual jokes at a woman as sexual harassment. Now that, I think, is jaw-dropping stuff. If you look at the column on the next to it on the right hand side, a man wolf whistling at a woman, you will see that it starts off just above 60% and then suddenly drops to 30% in the one instance, and for women, interestingly enough, it drops even further. But the point that I'm making there is the top 50% did not perceive that as sexual harassment, and so down the line we go. The next one, a man looking at a woman's breasts, you see the difference there, and you see the script. It says the biggest difference between men and women is over looking at breasts in that specific age category. The next one, a man placing his hand on a woman's lower back and effectively making the same point again. you can see 40% just average, but the 60% above it effectively not experiencing that moment as sexual harassment. And I think the realization, and looking at the next one, a man winking at a woman, also that percentage perceiving that as sexual harassment. The one next to it, a man commenting on a woman's attractiveness directly to her, also quite a percentage perceiving that as sexual harassment, and then a man asking a woman out, a very small percentage. But I want to make this point. The point is that we need to appreciate that the test for sexual harassment is effectively when you stand in the shoes of the victim. And this test, as the new code is finding itself and whatever it will look like, this new test are surely to follow a very similar approach than what we have seen in the past. So effectively, I think the point that all of this is making to us is it's making a point that I call it the jaw-dropping moment, because it speaks to behavioral training. It speaks to what an employer must do to be proactive, to speak to its employees and to train and make its employees as aware of how quickly sexual harassment allegations can be made, an understanding of the test, and effectively behavioral changing training that speaks to what one should and what one shouldn't do. We have had a number of discussions on that. We've looked at international practices and so on, and it is an absolute honor to have Makbool part of this, so that we can have a feel for how does this happen elsewhere in the world as opposed to just in South Africa. But most certainly making the point that quite important that we think about these things and that we concentrate and focus on how we roll out our training obligations insofar as the sexual harassment and racial harassment duties are concerned. The next slide gives us a summary of what Feroze effectively spoke about right at the beginning of our presentation. It talks about a risk assessment, and it highlights a few points in terms of where does that risk assessment operate, so that one understands that. And on the right-hand side, it's a call it a flyover of employer duties, and I will take you through that very quickly. The intention is not to spend too much time on this because it's very time consuming, but the intention is just to give you a feel for this, because I will return to this slide after we've looked at the basics. And then what you will find on the right-hand side is you'll find the black will disappear slightly into grey, and I will then highlight in red what I think the basics are requiring us to do. But this effectively is a holistic approach, especially on sexual harassment, as you can see per the heading. So starting off with a risk assessment on the left-hand side, i.e. what are we trying to achieve and what are we trying to avoid? The first circle there is reputational. We need to think about reputational risk. It is massive. Sexual harassment allegations, how we deal with it, formal or informal, whether or not it's resolved, what claims are instituted after that in public forum. You can ask listed companies that's been in our courts what the impact of that reputational risk is. It is severe. The second circle that one must consider when we look at a risk assessment is from a human resources perspective. You will see that I've used the HR acronym there. One, work disruptions. Why? Because sexual harassment and racial harassment will inevitably, if it's not dealt with, inevitably will lead to work disruptions. Absenteeism will be rife and productivity will go down. So all of those things are very important. Circle in the middle, money. I've used the dollar sign. Why money? Because the employer picks up vicarious liability, and that vicarious liability comes in the form of an award or an order for compensation. So effectively money will flow if there's a contravention of those employer duties. Very important, these employer duties, as you know, has been spelled out in the previous two codes, one code repealed, but the new code even more specific about these duties. Where does that liability lie? It does not just lie in Section 60. Section 60 is number 3 in that circle. Section 60 dealing with the Employment Equity Act and the liability under the Employment Equity Act. Liability also sits in one, a safe work environment, and there's a reference to the Grobler case as the Supreme Court of Appeal pronounced on it, even for a first incident. And that liability stems out of a breach of not providing a safe working environment. So that was in the High Court. Second one, vicarious liability, that was direct vicarious liability for a first incident. And you will see there, I refer to the Grobler case, but the High Court, the court a quo, effectively finding vicarious liability as a direct liability after he looked at a number of approaches from international courts. That's what the High Court did, but as I say, the SCA effectively landing in a safe work environment. So very important to appreciate that not complying with those duties effectively exposes the organization, the employer, to compensation and damages awards. If I turn to the right-hand side, the employer duties one, I'm going to just go through this pretty quickly. And it unpacks, you will see the dollar sign again is the start off of that circle. So I'm going to run through it very quickly. First of all, sexual harassment policy. We know that must be in place. Secondly, induction and training. Proactive approach being demanded by the old code and so the new draft code and expected to be in the final code. And that relates to all employees. The definitions, policy, processes, and behavioral tools to say no. Now, that being quite important, you will see that I will return to that point in red in a later slide. 3, effective communications in your policy. That's a requirement. 4, awareness for all employees. That's a requirement. Obviously, doesn't help if you have a policy and people are not aware of it. 5, training, human resources and management, also a proactive initiative. 6, sexual harassment specialists. I just want to pause there for a moment and basically make the point. I know the University of Pretoria has been presenting sexual harassment specialist training. Now that is indeed something that I advocate for, and I do say that this is required. And the reason for that, you can just look at this presentation. I think it speaks for itself. Sexual harassment and racial harassment, as the new code is presenting it, is requiring specialized skills and a specialized understanding on how to deal with sexual harassment and racial complaints. And I do think we need to think about that as employers and advisors on how we make provision and how we cater for, and are we really doing what we should be doing insofar as we do not provide a specialist service. So I'm making the point there, sexual harassment specialist, human resources and management, and what rolls under it is an understanding of what is to follow, being 6.1, immediate report, 6.2, immediate action. The employer must take immediate action, and the employer needs to think about who engages in that consultation obligation. So that consultation obligation, as we know, stems from section 60 sub 1 of the Employment Equity Act. But we need to ask the question, who are we tasking to engage in that consultation process? In other words, is it a sexual harassment specialist that understands the workings of what the Act require? And also who, from a perspective, what gender, race, and level of qualifications do we use to engage in those consultations? 6.2, informal versus formal approach. We know that that is what the code has done, and the new code is doing the same thing. But effectively on the left-hand side, I'm unpacking informal. This document talking about, and very important in my view, informal internal mediation as well as informal external mediation. Effectively making the point that when we draft our policies, we will be well advised to include informal internal mediation and informal external mediation to make sure that an employer does retain that right of informal external mediation, for example. Jointly with the complainant, so that one can do whatever what is within one's ability to do to deal and resolve with typical sexual harassment complaints. Now, it is true that there's an obligation on the employer to step in anyway. That is a topic, and it's a very important topic for us never to forget, but effectively, as I said, I will return to that. 6.2.3 on the right-hand side, that is the formal approach, formal investigation and formal disciplinary process. That is what we're really used to as HR and employment law advisors. That is what we are very used to. And then asking the questions at the bottom. The Act or the code also talks about the duty to advise, the duty to assist, the duty to provide counseling, the duty to investigate. And I'm asking the question there, who? In other words, the employer needs to think about who do they use and who do they brief to advise, who do they use and who do they brief to assist, who do they use for counseling, and who do they use to investigate. So very important to know which people are playing what roles and what the final product must look like. For example, an investigation must end up in an investigation report. 6 to 8, an agreement form. It serves little purpose, and let me just make that point. So this is like flyover on employer duties. It serves little purpose to go through a sexual harassment complaint, have it resolved informally, but there's no recordal of that moment. I just want to say that again. That is so important. I want to say it again. It serves little purpose to go through a sexual harassment complaint, resolve it informally if there's no recordal of that informal resolve. This doesn't speak to the employer's duties to step in, but it most certainly speaks to whether or not that matter has been resolved. Keep in the back of your minds that the debate or the background against which we are discussing this is vicarious liability of the employer. So that being, I would call it a flyover over employer duties. Now, what the fresh approach, and I tried to give a bit of spice to the presentation, so to speak, by asking these questions. Are we getting it right? Do we approach sexual harassment cases as a tick box approach, or do we approach it as really trying to understand it? Do we run lengthy investigation reports? Do we run lengthy disciplinary hearings? Do we then add to all of those investigations and disciplinary hearings internal grievances that jumps through levels 1, 2, and 3? And then on top of that, do we have separate sexual harassment complaints in terms of our sexual harassment policy? So just stop there for a moment and just imagine you receive a complaint from a staff member, and it starts off with the following in the opening paragraph, that this is a formal grievance, a sexual harassment complaint, and a protected disclosure under the Protected Disclosures Act. What will that mean? Does it mean that you as the employer are now going to follow all 3 of your procedures to deal with this? So I'm just asking that question for the moment. You will see that we're returning to it later. And those things obviously leads to lengthy arbitrations. It leads to criminal trial approach because we are overly cautious in terms of our liability, and then what one then does is one then overcompensate in terms of lengthy arbitrations, lengthy investigations, lengthy disciplinary hearings, and that's most certainly what we've been seeing out there in our experience. So our experience has shown us that we find this out there, that we are in fact causing a disservice, I would suggest, to our clients in running 30-day disciplinary hearings, just as a matter of example. Fresh approach back to basics. What is the basics and what are we missing in terms of the basics? The first thing that we are asking, can we make what appears to be complicated simple? The second, what is the purpose that should be of the Employment Equity Act? To achieve equity by promoting equal opportunity and fair treatment in employment and through the elimination of unfair treatment. That is the purpose of the Employment Equity Act that we must try to achieve. It continues in terms of what is the main purpose of the code. So if we've looked at the Act, what's the main purpose of the code? And it refers to both the 2005 and then the 2020 code that I presume when it's finalized, it will be the 2021 code. It also includes racial harassment. This is what it refers to. It says we must provide a safe workplace free of harassment. And the context is abuse of power. So we need to understand that that was the context in which the purpose is positioned. Secondly, elimination of unfair treatment. Thirdly, clear policy on behavior and process. I call it a bottom-up process. So that is a moment that I would just like to pause by basically saying the bottom-up process requires employers to sit down and think about these policies and these procedures as we draft them, is effectively allowing employees to put complaints into the employer's system and procedures and then force the employer to deal with them. So that's why I'm calling them a bottom-up process. But in appreciating that you're creating bottom-up processes, it is very important to be focused when you draft those processes, that a specific process is triggered for a specific complaint, i.e. that you can't have one complaint that then suddenly runs 3 different processes. Understanding sexual harassment, also very important. Employer duties, very important. And then informal and formal procedures, it's kind of what we looked at. Now, if I apply, in my view, applying the basics to call it the overall proactive look at employer duties effectively looks like this. So what I've done, I've I've taken some of the black into grey, which effectively I'm saying they remain important, they remain duties, but in asking the question, are we getting it right and are we focusing on the right issues, I'm suggesting the red on this slide is what is the right issues. Now let me go to them again. You've seen this before. I'm going to go to them again. 1, your harassment policy. It requires the employer to carefully contextualize that it has clear policy drafting in presenting its policies. Now you will see there I've included a Mercedes-Benz sign, and I will go to that in my next slide. It's basically just to put it in there so that everybody can just see exactly where that next slide fits in. But effectively I will return to point 1 in the next slide. The second one, induction and training, being proactive. I'm laying the emphasis there on the definition of sexual harassment, for example. You will remember my initial slides was the jaw-dropping moment. I'm making the point that it is quite important on focusing on behavioral training and understanding what the definition is and understanding how quickly sexual harassment allegations can be made, and then also with a focus on behavioral tools to say no. In other words, are we focusing our training on the right things to create a workplace that is free of sexual harassment? That for me is the pause moment if you follow a fresh approach to sexual harassment. I'm then jumping to 4. This obviously ties into awareness training of all employees, being a proactive measure of ensuring that. 5, training HR and management proactive and sexual harassment specialist. Obviously the sexual harassment specialist will be very involved in all the rollouts, that what the policy will look like, what the training will look like, etc., and effectively understand all these different circles and dynamics and context and background that I've been talking about. The focus then becomes, if you look at the red on resolve, on 623, informal process to resolve, and specifically if you look at 6232, talking about informal external mediation. Why informal external mediation? We have found, and experience has shown to us, that external mediation very often brings about a resolve to complicated complaints. Why is that so? It is so because of the lack of trust, of course. It is sensitive complaints. Lack of trust is everywhere. Will my employer kick it under the carpet and not really deal with it? And I'm making the point victims want to be heard. And I'm also making the point about being flexible. So what the code initially, in my view, and why informal process have been carved out, is because it wanted to lay emphasis on being flexible and effectively appreciating that it's all about the victim. It's all about the victim, and that requires flexibility. Yes, the employer's got a duty to step in. I've made that point. It remains real, but effectively the focus remains on the complainant and effectively how to carry that over. And I am saying what's extremely important, if you look at 624 up until 628, is a very careful think about who is to advise, who is to assist, who is to counsel, who is to investigate, and a recordal if it is resolved, a recordal. We're aware of settlement agreements by employers that is not upheld in terms of you are still entitled to prosecute. This is not really talking about those settlement agreements. This is talking about capturing if a matter has been resolved informally. In the next slide, that is what I referred to as the Mercedes-Benz slide, just for lack of a better description. It's all about applying the fresh approach and back to basics on clear, and where does it take us? It takes us to clear policy drafting. So this is making the point and bringing an appreciation of employers needing to review their policies, to appreciate that if, for example, and what you find on the left, employment equity harassment policy or sexual harassment and racism policy, it requires clear policy application. You find the same point under PDA. PDA for our international visitors, we are all very familiar with that. It's the Protective Disclosures Act, but it's effectively South Africa's whistleblowing legislation, but also their clear policy application. In other words, if a complaint is laid, a complaint must either be processed from the protected disclosure perspective, or it must be processed from sexual harassment. It is true that a protected disclosure complaint can migrate into a sexual harassment complaint once it's clear that that is where it sits. But effectively the point that I'm making, that clear policy drafting is required. And I'm making the point right at the bottom of the slide that grievance policy just as important. This is the bottom-up processes or procedures that I've been talking about. Your grievance policy also needs to be clear that this is not the policy, grievance policy is not the policy that is catered or tailor-made for sexual harassment or racism complaints or for protected disclosures. And clear policy drafting effectively is the only way for you to have clarity on how these processes will be followed and will be managed. We know the Protected Disclosures Act, for example, has got its own measures and requirements in terms of how one should go about in dealing with a protected disclosure. And I'm making the point clearly, the Sexual Harassment Code does the same. So I'm then returning to my last slide. This last slide is effectively just a final conclusion of trying to making what's complicated simple. And it says to conclude, is harassment disputes that complicated? Is it really that complicated? And I'm venturing into the field of saying if we break it down into simple bite-sized chunks, it looks like this. From an employer perspective, 1, non-discriminatory and a safe working environment. That's what we need to provide. 2, we need to do clear policy drafting. 3, we need to focus on behavioral training. So both behavioral and compliance training, but I'm making emphasis on behavioral training. I'm effectively saying that is the jaw-dropping revelation on do's and don'ts. And then in red, I'm saying e-learning and m-learning. And the reason why I'm bringing that in is I'm effectively saying, are we using technology to take e-learning? And e-learning, we all know, that is when we sit in front of our computers or our laptops. Are we taking e-learning into mobile learning? So that's the difference between e-learning and mobile learning. I know Aequitas has been doing lots of work in this area. But effectively mobile learning, where you can have a cell phone that talks to you in terms of do's and don'ts, how quickly this will happen, and effectively focusing our training on the right area and in the right context. So yes, compliance training, but most certainly what I am presenting here is that we need to have a renewed and a fresh focus on behavioral training to really speak to what's, in my view, the jaw-dropping revelation. In other words, a video on a mobile learning app that effectively can explain to you what sexual harassment is all about is the way that I think awareness is created properly, going down in an organization from the top to the bottom. Right at the bottom of the slide, we have the other two. I've mentioned these role players before, complainant and harasser. And I'm basically just saying, highlighting that the focus there should be on resolve, employers step in if and when required, and early and cost-effective resolution of disputes should be our focus when we deal with sexual harassment. Feroze, thank you very much. I've certainly enjoyed it, but can I hand it back to you? Maybe there's some questions.
Thank you very much, George. There are a few questions. I don't think we're going to get through all, but I'm not sure if you can see them on the screen. But I want to try and capture about 3 of the questions directly by summarizing it. So you importantly highlighted the fact that an employer's liability can arise from at least, 3 sources. It's own duty to create a safe working environment, and you can breach that. Then from the Employment Equity Act, but that liability is dependent, as I understand it, in terms of Section 60 on 2 things. One is the incident must be reported, and the employer must then be shown not to have taken reasonable steps to deal with it. So there are certain preconditions for that liability. But for me, the greatest risk seems to be from the common law concept of vicarious liability, where an employer can be held liable just for one incident. And I think there's a famous Constitutional Court case of F versus the Minister of Safety and Security, where an off-duty policeman who was on standby used his vehicle to rape a victim. Now, it wasn't in the employment context, but the minister was held vicariously liable for damages for the single act of the policeman, even though the policeman is there to protect the public. Why? Because the court looked at the constitution, the policeman's obligations, and said that the police had employed him and was supposed to employ trusting police officers, and he had used his car, and that was sufficient to attach liability. So what I'm interested in, this really broadens the scope of employment liability. A lot of the policies focus on avoiding liability under the EEA. I've seen very little policies that have actually tried to compile risk assessments to do away with vicarious liability. If I can just have your comment on that, George.
Thank you, Feroze. You're quite right, and I mean that constitutional court case focusing on the delictual liability stemming from what is known as the duty of care. So effectively opening up that vicarious liability line in terms of delict. But you're quite right in making the point, and the judge in Grobler, in the High Court matter, the Kota Quo, effectively looked at vicarious liability in that very same context, not in the context of duty of care, but effectively saying that an employer is liable if sexual harassment occurs without necessarily focusing on a safe working environment. It was indirect, but he came to that conclusion after he looked at, very interestingly, 6 different countries' approach to sexual harassment. He looked at the UK, he looked at Canada, he looked at the United States, he looked at Australia, and effectively finding case law in all those jurisdictions, holding the employer vicariously liable, and this is now vicarious liability under delict for sexual harassment, not under the Employment Equity Act. You are, in other words, I fully support what you are saying, that if one unpacks what happened in Grobler, that is exactly the liability that is very real, and talks to, obviously, all of these things eventually ends up in some kind of monetary award or judgment. So effectively, quite right. It is definitely broader than the Employment Equity Act. The Employment Equity Act is what provides for what I could call a statutory vicarious liability deemed provision. So that section talks about deemed to be liable, and we translate it into vicarious liability, but most certainly the delict concept of vicarious liability, a broader concept and very real and acknowledged. If you look at the High Court judgment, acknowledged after looking at international case law and supported by the Supreme Court of Appeal. So quite right.
Thank you. There are a few more questions, but in the interest of time, we have about 15 minutes left. I'm going to ask Makbool to do his presentation, and if we have some time left over, perhaps we'll try and deal with those questions. Otherwise, whoever has questions can just email the organizers, and we'll pass it on to the panelists to answer specific questions. So I'm going to invite Makbool Javaid. He's a discrimination specialist. He's from Access HR Consulting, which is based in South Africa and UK, and is also a prominent UK attorney dealing with issues. So Makbool will share with us some of the international learnings and the risk environment, particularly from the international perspective, to see what the risks are and how far the jurisprudence has gone in those areas. Thank you, Makbool. I'll give it to you.
Oh, well, thank you, Feroze. And I'm grateful to be part of this webinar. And it's been fascinating listening to Annelie and George in relation to this particular issue. Now, I mean, Access came about because obviously this is an issue which it has come up across the globe, and I mean, essentially, as Annelie and George have said, I mean, the issue of vicarious liability has meant that the focus is on the actions taken by the employer to eliminate harassment and discrimination at work. So that's the global trend, and Access came about because employers were getting it wrong in various jurisdictions, and as George has pointed out, the courts have been looking to learn from other jurisdictions as to how this issue can be tackled. I think broadly speaking, the position is that when it comes to harassment or bullying at work, then the employer has to be proactive. The liability will be with the employer unless there are extenuating circumstances. So it's very difficult to get out of liability, and as the law on vicarious liability is developed, this is the sort of global trend. And as Annelie has said, there's a distinction between harassment, which is linked to protected characteristics, so it's race, sex, religion, or sex, and bullying, which is generally a breach of contract, and is sort of in layman terms, you can say an environment is created where the individual feels they're forced out of work and they have to work in an intolerable environment. Now, why are we talking about this? The headlines in the UK have been overtaken recently by an incident involving the Home Minister, Priti Patel, who has been accused of bullying. And the Prime Minister, Boris Johnson, asked for an independent investigation to be carried out by the individual who carries out these investigations. And the investigation found that the Home Minister was in the habit of using forceful expression, accusing on some occasions shouting and swearing. Now, there's a history to it which we don't need to go into, but essentially the allegation is that the Prime Minister watered down the investigation's findings and forced the investigator to come to the conclusion that this may not have been done intentionally, but it had the effect of creating an intimidating work environment for the civil servants around her. Now, the Civil Service Code itself accepts that, legitimate, reasonable and constructive criticism of performance doesn't amount to bullying, but intimidating and insulting behaviour does. Now, I want to use the Priti Patel case to illustrate some of the points I want to make, that the global trends as I see it. Now, as I say, this has been in the headlines. There's a deep criticism made of the Prime Minister Boris Johnson that he has not dealt with an issue, particularly when he has said that bullying will not be tolerated. So the position is that we need to look at what works and what doesn't work. Now, clearly, if individuals don't have a trust or confidence in the system, then the problems are going to go under the surface and will carry on. Now, I think this is important because what employers need is an early warning system. We need to be able to identify issues which are causing problems before they erupt into a much bigger issue. And that was part of what Priti Patel's case was about. It was said that she had behaved in this way in the past, and she herself claimed no one raised it with me. And what employers find is that where there's a lack of trust and confidence in the system, individuals will put up with small indiscretions, and that will then create a volcanic kind of environment where there's an eruption and then things cannot be repaired. So we need to build a system where there's trust and confidence. Employees also, where it goes wrong is where they feel there's a lack of support, that they don't have any mechanism whereby they can raise these issues. And we'll look at some of the tactics that can be used in order to deal with that. Also, now we know sort of there are social pressures. There is this sort of American term of snowflake, which is used. Individuals are ultra sensitive, and therefore, no one wants to be seen as being too ultra sensitive, and that stops them raising issues when we want them to raise issues. There's fear of retaliation, that they may lose their job, that there will be sort of victim shaming as a result. Now, what does work? What works is that you have a sort of image, a reputation where you have a zero tolerance environment, where employees feel that they are going to be listened to, they're going to be supported, that the brand itself is so strong because of the leadership statements. Individuals feel that it is a safe working environment. So that your image and what you say externally, internally is important. You also need to have mechanisms like a survey internally in order to see how staff feel. So regular surveys to look at what the atmosphere is like. Do employees feel under pressure? Are they stressed? Do they feel harassed? Is there a bullying culture in the environment? The only way you're going to capture that is by carrying out surveys. Also, you need an innovative communication strategy. It's not enough just to send a bland email from the chief exec of the managing director about how people should behave. Let's try and be innovative, maybe using posters, using something, some innovative sort of campaigns, having events, making it clear that we want a safe working environment where bullying won't be tolerated. Obviously, we need a diversity and inclusion strategy as well. So what are the practical measures that can be taken? These are the kind of broad features. We need an effective, speedy resolution process. George has touched on this, and Annelie has as well. Comprehensive training program. We need our employees to be trained. We need to set out what the rules are. When you enter the world of work and you work for this organization, these are the rules, and that's how you must behave. A consistent universal sanction mechanism, so that we know what the sanctions are if there are transgressions. If we step over the line, there will be certain sanctions will come into play. Once again, the Prime Minister of the UK, Boris Johnson, has been accused of being inconsistent, that he's let the Home Minister off the hook when she was found guilty of bullying, and therefore that reduces the confidence that individuals have in the system. And as I say, what's important is having an early warning system, so that we know what it is that we expect of employees. And if we are inconsistent, then that's not going to work. Yes, policy framework, of course, but getting a template from the internet or one that's been used for the last few years is not going to work. Having policies dealing with grievance, harassment, and discipline need to be made fit for purpose. They need to be reviewed. They need to be tailored to your working environment. They need to be targeted to the kind of environment that you have. Zero tolerance organizational culture, and that comes from the top. The leadership must send the signal that we have zero tolerance. One important area is having an internal mediation scheme. Now, George touched on this. What we want is resolution. We don't want court cases. We don't want lengthy hearings where there are staff are being involved in some kind of judicial process. We want a mechanism whereby individuals can resolve these issues, and we can do that if we have a mediation scheme. We can train our staff internally or bring in external mediators to be able to resolve these issues. So those are the broad kind of measures that can be taken. So let's look at some in companies. Now, I've used well-known companies like Facebook. So Facebook have had their complaints about them of harassment and stuff. So what they've brought in is compulsory training for managers under California state law. Every manager has to have be trained in dealing with harassment issues, how to behave and how not, or what not to do. Anonymous harassment hotline. We need a way whereby individuals can raise these issues, and they need to be able to do it without fear of retaliation. So if we have an anonymous hotline where they can report cases of harassment, they can be investigated. That can be by telephone or online, and Facebook, obviously being a tech company, have an online facility as well. We need to have specialists in the HR team or in the legal department who understand the issues of harassment. And we know that it requires a particular skill and understanding and a particular approach, which isn't the same as other disciplinary issues. Interestingly, Facebook, and I think this is quite novel and we can learn from this, take the view that if you witness any kind of harassment, discrimination in the workplace and remain silent, then you're complicit. Therefore, the training that I've mentioned involves what's known as active bystander training. This is trying to inculcate in the work environment this idea that all employees have a duty to intervene, to stop harassment, and it's not just the individuals involved. And George, on his slide, showed that it's the three parties involved, the employer, the harasser, and the complainant. But Facebook go further than that. And I think there's a lesson in that, which is all staff have a duty, and that's why active bystander training is important as well. Interestingly, they also have a dating policy. We know that many of these issues, and the case that George talked about, which went to the Labour Appeal Court, was about an individual, making an advance to another employee. A dating policy sets out what are the rules. We expect employees to be able to navigate their way around these issues without giving them any kind of rule book. It may seem very superficial, however, it works. And Facebook have a dating policy, so everyone knows what the rules are and what they can say. And for example, you're not allowed to ask someone out for a date if they don't work in the same environment, if you don't know them, and you can't do it online. And all these, if you don't comply with it, will lead to action. What did Google do? Another global company, very successful. They have an employee support program, so that if any individual feels that they have been subject to harassment, there is a sort of facility available to them. They will get support, they will get advice, they will get individuals who will go with them along to any investigation meetings, so they feel supported. Under US law, many employers have arbitration clauses whereby you can only go to arbitration. They've realized that this doesn't work, and therefore this is optional. You can take it further and you're not bound by the arbitration clause. When it comes to selection of candidates, there's a requirement that it has to be diverse. Those of you familiar with American football will know about the Rooney Rule, which means that any time there's a vacancy, there has to be a diverse range of candidates going through. Supplier code of conduct, that's come up. We've talked about, and Annelie touched upon it on third parties, so that our suppliers will also have a code of conduct. Publish annual discrimination statistics. One of the arguments was that these companies cover up these cases of harassment, particularly sexual harassment, and therefore there needs to be transparency. So Google have committed to publish the statistics, how many complaints. Mandatory training we know about. Another interesting feature that we haven't come across is Google have a policy in relation to social events. They have a 2-drink limit at social events because they say, and this is on their website and you can check it, that many of the cases of harassment that occur relate to alcohol consumption, and therefore when they have events, they're going to limit it. They have a ticketing system, and this, they say, has reduced the amount of harassment. That's something to think about. Let's go to another company, Microsoft, another global huge company. HR investigations, have a specialist team of HR that will do the investigations, who are trained in dealing with harassment cases. Any kind of disciplinary measures that go around outside of a fixed range have to be approved by corporate vice presidents. The reason is to prevent cover-ups, to prevent these issues being hidden. And therefore the senior people have to sign off on them. This is really interesting. One of the criticisms made in the UK, and I'm sure in South Africa as well, is that the outcomes take forever. You could be waiting 6 months, 8 months, even longer, because you have these long convoluted hearings internally, which take a long time to come to an outcome. Microsoft committed that in these cases, outcomes will be given in a month. Once again, publication of discrimination statistics, transparency, having an employee advocacy team, as with Google and Facebook, having a team of individuals within the organization who are able to help employees who face harassment, and also ban on arbitration clauses so that you cannot force employees just to have arbitration in relation to harassment claims. A novel approach, and this is something that you may find very interesting, is having what's known as a traffic light system. Psychologists have found that when individuals engage in harassment, if they are sort of chastised or pulled up, they become very defensive and try and justify their behavior. So one way of getting around that is, rather than focusing on the individual, to say, look, you know, John or Paul or whatever, you're doing X, Y, Z, is to look at the behavior itself. So companies have introduced what's known as a traffic light system by saying, well, that was a, an orange conversation or orange behavior. This means that you can then tackle the behavior rather than the individual becoming defensive. And as you can see, behavior is categorized using the traffic light system, so that where it is good and positive, it's green, and where it becomes disrespectful, demoralizing, or alienating, it is orange, and yellow for rude and insensitive, and where it becomes unlawful, it's going to lead to real issues. You say, well, that is, that was a red comment or red behavior on your part, and the idea is to try and tackle harassment in that particular way. So I think all these lessons are ones that we need to try and instill into and build into our own organizations to see how we can tackle this problem, which is increasing and not reducing, as we've seen from the trend globally. So on that note, Feroze, I conclude my part of the presentation. Thank you very much.
Thank you very much, Makbool, and others. From my own perspective, the presentations were absolutely phenomenal. And I think just to round it up, most employers would basically cut and paste policies and models from other workplaces. And this is a system or a recipe for disaster. So what I can gather the speakers are really saying is, you need to know your own employment environment. You need to perform a subjective risk assessment from the employer's perspective. Look at how far your workplace stretches. Look at the risks within your workplace and beyond your workplace, and compile a subjective risk assessment fit for purpose for your own workplace. But more importantly, I think you need to know your workforce, because the test for sexual harassment is a subjective test. It's subjective with an objective basis, but you don't want to find yourself in a situation where the victim views something as sexual harassment, and that view may be found to be reasonable, and you or your senior management may not take that view, because that's a recipe for disaster and a recipe for financial compensation. So employers need to actually know their workforce. And the only way you know your workforce is then to have regular appraisals, regular training, regular questionnaires, to be able to assess within your own work environment what your own staff consider as red behavior, or as Makbool says, yellow or orange behavior or green behavior, so that you understand your workforce particularly, and you can design your policies and mitigate the risks of vicarious liability and liability under common law and the Employment Equity Act much more easier when you show that a company is very serious about combating sexual harassment and having a zero tolerance policy. And I think there's a lot to learn from each one of from the code. There's a lot to learn, because although the code is a draft code, I think that whether or not it's published, the law is going to get there anyway. So it's better to plan and ensure that your policies are proactive, so that you don't find yourself wanting and on the back foot, and you plan for all possible risks in the workplace. So I think from my own perspective, it's really been an excellent presentation. I myself have learned a lot, particularly from an IR perspective. As lawyers, you normally employed after the fact, and this is all proactive intervention that employers hopefully can learn from and use these examples. I know there have been other questions. I think majority of them have been covered in the general presentations. But if you feel your question hasn't specifically been covered, please feel free to email the organizers, and they'll pass on the questions to the panelists, and they'll hopefully answer your specific questions individually. So I want to thank everybody for joining this discussion, and certainly once again, thank you to all our presenters. You've put in a phenomenal effort presenting these slides. You can and putting a lot of work into it. I want to thank you, and I hope that everybody benefit from this presentation. I want to thank everybody, and unless there's anything final from the three of you, if you want to round up, I'll give each one of you about a minute just to say make some concluding remarks. So we'll start with Annelie, then George, and then Makbool.
Thank you. It was lovely being part of this, and would love to share some more of the information if anybody wanted to have that in terms of an integrated approach.
Thank you, George.
Thank you. Thanks, Feroze, and thank you, everybody. It was absolutely a privilege to be part of this panel. And I think we all are striving towards doing the right thing. I think what we're seeing here, I mean, having an internal drafter perspective and a UK perspective and a global perspective just helps all of us to understand and to learn from each other. So no, thank you very much. I think we all have lots to do and lots to learn to provide a safer working environment. That's what it's all about. Thank you.
Thanks, Makbool. Anything from you?
Yes, I mean, it's been a real privilege and fascinating to hear from the other presenters as well. I think what we need to go away with is the idea that employers need to be proactive, we need to have early warning systems, and that, as you rightly say, we need to know our own working environment. We need to find a way of finding solutions that fit our working environment rather than having a one-size-fits-all. And the way that the law is going, public opinion, it's all about being proactive. Gone are the days when employers could sit back and say, well, you know, we recruit from society, so individuals come in all shapes and sizes and we can't stop this kind of behavior. The courts are not going to tolerate that. That's been the case in the US, in the UK, and throughout the continental Europe and in South Africa. You know, and particularly this has arisen from the Weinstein case, the Me Too movement, and information sharing means that our employees are going to require a better approach than has been the case to date. So I hope that is the sort of take-home message that we all go away with as we share our own experiences and the information. Thank you.
Thank you very much. And with that, I say goodbye to all of you. Thank you.
Goodbye all.